Mr. Meady, suit.
My lord, my lady, without further ado, the next point, and our second sub-ground appeal at 1-2, is the judge's error where we say he required, that Section 48 requires a defendant to show continuous use of the mark rather than focusing on continuous acquiescence. Now, the judge identified this as an issue in paragraph 175 of the judgment for the first time. He says there's contention by the claimants that for certain parts of the 5-year time period relied on by the defendants were not actually using their mark in any meaningful way. But he revisits this later in the judgment at around paragraph 245. Is that right? Got it. So 235, sorry, was there in any event continuous use? So the judge made it clear it was a requirement that he'd found. There was a dispute as to whether or not this had been pleaded. We don't take a pleading point. But what I do say is that although the judge held at 238, 235 he says, was there in any event continuous use? And he refers to the claimant's argument that there was no continuous use. At 238, he says, I've set out the text of section 48 above. It provides the relevant defence arises where the proprietor of an earlier mark has acquiesced for a continuous period of 5 years in the use of a registered trademark. And then he asserts, or just concludes, the burden of showing continuous use rests on the defendants. See section 100. Now, requirement to prove use is on the defendants. That's fine. But he doesn't report or record the arguments in relation to whether or not there had to be continuous use, and he doesn't give his reasons as to why he says there must be continuous use. Now, continuous use of the mark as opposed to continuous acquiescence is not, we say, in the wording of the statute or the directive, but the judge took the view that the requirement that the claimant had acquiesced for a continuous period of 5 years also required the use to be a period of, to be continuous over that period. And once he had imposed a requirement of continuous use, despite my client's submissions, certainly in the oral closing, that was not necessary, once he'd imposed a requirement of continuous use, then he was compelled to come up with a level of use that had to be satisfied for continuousness, if I can put it that way, and that's our next ground of appeal. Now, of course, I must accept as a matter of reality that if acquiescence is to go on for a period of 5 years, it must be possible, if use is abandoned in a period of 5 years and completely stopped, that might interrupt the period of acquiescence. There are edge cases. You can see how if use had stopped completely and been abandoned, that there was no longer acquiescence in use that was, properly speaking, abandoned. So some period of cessation of use might, in an extreme case, be enough to mean that there was no longer acquiescence. But a requirement of continuous use is an unjustified gloss, we say, on the statute and the directive, and we say, in any event, in the light of the website use, is inconsistent, is not right on the facts of the present case. But I'll come back to the website
So
use.
let me see if I've understood that submission. You're saying it's one thing to posit total abandonment of use. It's quite another thing to require non-interruption. So let's take the case where the junior user ceases using, let us say, for 1 month.
Oh, my lord.
Does that count? And if that's enough, does 1 week count? If 1 week counts, does 1 day count?
Well, my lord,
if 1 day counts, does 1 hour count?
My lord, we're into a paradox of Zeno as we divide it further, and I say none of those would work. And I would say that this is what's important: is one can acquiesce in use. One can continuously acquiesce in use that is not continuous. My lord, my lady, I give you Christmas goods or cream eggs. Assume a seasonal good such as a Cadbury's cream egg that is notionally only available from, it appears to be Boxing Day through to Easter, and the use then stops. It would be absurd, in my submission, to say that someone who had stood by for 5 successive Easters in such seasonal use had not acquiesced for a continuous period of 5 years because the use had interrupted seasonally. Same for Christmas goods, so on and so forth. And that reveals the fallacy in the approach of saying that use must be continuous for acquiescence to be continuous. Now, I do, because I think there must be some hard case to make difficult law, if use were abandoned, positively stepped away from, and it appeared clear either that there was to be no further use because a statement had been made, this line is out of business, you might think, well, okay, I'm no longer acquiescing because it has been drawn to a stop, or indeed, if the entity in question had gone bust and was no longer there, you might say that a successor in title might not be able to rely on that. There might be corner cases in those ways, and I don't think that falls within the scope. That is a question of, is there acquiescence in those particular circumstances? But what is wrong as a matter of principle is to do what the judge did, which is to assume continuous acquiescence, and remember what the directive really says is acquiesce for a successive period, a period of 5 successive years, amounts to, or carries with it a requirement that the use be continuous.
I mean, I suppose, assuming that if you were right in your conclusion, there might still be 2 ways to get there. Either you say there's no need for continuity, or you say where you have something repeated at regular intervals that is continuous.
Well, my lord, possibly, but again, it adds in my respectful submission, that adds it's inventing a problem where there is none afforded by the words of the statute. What one considers is continuous acquiescence for a continuous period of 5 years. One doesn't have to think about whether the use. One looks at the conduct and is there acquiescence. And that also, the judge's approach leads to what I'll deal with in my next ground of appeal, which is the level of use that needs to be continuous. And here, it's important to bear in mind that what the judge came up with was something akin to the non-use provisions under section 46 of the Act, but requiring them to be continuous, which is above and beyond what even the non-use provisions require. So we say it's an unjustified gloss on the statute and the directive. My learned friend takes 6 points in response, and I'll deal with them rapidly because it will narrow down my reply points. These are at his skeleton following paragraph 28. So behind tab 4 at page 54. First, he says, it's right as a matter of language. That's the point I've addressed, and I refer you to cream eggs. It's not necessary. It doesn't follow necessarily as a matter of language. Continuous acquiescence, or acquiescence for a continuous period, does not require use for a continuous period. The second point he raises is the legislative history, and he refers to the Article 9 and the recital at 11. Recital 11. Again, this can be read either way. It doesn't take matters further forward. That's perhaps the vice in this. It doesn't engage. If one reads it, one reads the terminology knowingly tolerated the use for a substantial length of time. Does substantial length of time qualify knowing toleration? I would say yes, it's knowing toleration. He says it qualifies use.
So there must be awareness for 5 years.
There must be, well, the question of whether, we come on to knowledge on the next one, which is whether even that awareness must be continuous. Do you have to be thinking about every hour of every day? Do I need to wake at 3 in the morning and think, well, I know they're using? Or are you aware at the start and that's enough to set the clock running? So there's, again, continuous knowledge, in my submission, is also a further gloss on the requirement. You have to look at the state of acquiescence. That's what must be continuous. Now, again, in relation to to the facts of the present case, this may all be by the by, in that I don't think it's disputed that the website they were aware of all the way through, and the website was use which was considered infringing and so needed to be restrained. But where that comes in, and the judge, I think, disregarded the website, is because the judge held that the use of which knowledge, continuous use of which knowledge had to be continuous, was use of sales. It was to do with sales and the level of sales going on, rather than considering all the other classes of potentially infringing use. And indeed the specific infringing use complained of, use on the website, which was not sales. So, and we'll see that when we come to the knowledge provision. So that was my learned friend's second point. His third point, saying why continuous use is there, it is to refer to commentary. Now, that's set out under paragraph 31 of his submissions. He underlines various bits. I'd underline others. It's none of these are supported by authority, and so are not anything other than setting out a potential approach that seemed sensible to these particular authors. But dealing first with the EU trademark regulation text, European trademark law, a commentary, the assertion by the authors is acquiescence requires not only an activity on the part of the owner of an earlier right for 5 successive years, but also the continuous use of the later trademark. And then they say it would seem unjustified to impose limitations on the owner of the earlier right if the latter remained inactive because the junior user had stopped use for some time. Question of degree. It might well be unjust if they had ceased, completely abandoned, as we discussed, or so on and so forth. But it's certainly, to say that there must be continuous use is, in my submission, going too far on the part of those authors. And similarly...
Well, and they go on to say which period of non-use is necessary to assume an interruption not yet
has not been considered, so they recognise.
So they recognise that a short period might not be enough.
Yeah. And then how short, and then what, and round we go. And similarly, David Keeling's commentary, not in Curley, but in the concise European trademark law, we have him saying this means, on the one hand, the EUTM must have been used continuously during those 5 years, or at least that the EUTM proprietor could not have been deemed to have abandoned the trademark for 5 years. So, I mean, that I might accept his latter point there. But again, it doesn't take matters much further. It's, in effect, submission by another means. It's not referring to any binding authority. The fourth point my learned friend relies on is he refers to Dynarod. I would just see what my learned friend has to say about it. The Dynarod, there was no counter-representation in that argument. I think his lordship, Lord Justice Burse, in IPEC as it was then, or the Patents County Court as it was then, essentially came to this conclusion off his own bat without support and submission. So although it's interesting to see, it doesn't take matters much further. And high-tech and high-tech, we've looked at this, and my point, I think, to your lordship was that in high-tech there was indeed an uninterrupted period, and that's all they're doing is recording that. It doesn't say what the effect of an interruption would have been. Fifth point, German commentaries. Again, I'll see what my learned friend makes of them, and I will hand up at the end of my submission, so I'm not tempted to dive into them and take up what little time I have this afternoon, but I have the German texts, and I've given them to my learned friend, that he can address them tomorrow morning if need be. And then the sixth, my learned friend postulates an extreme position that might lead to acquiescence clock starting ticking. I can well see that if that were the position set out, that maybe that would not amount to acquiescence, but it's on the facts of a hypothetical case that are not before you. And as against that, again, I cite the authority of cream eggs and Christmas products. One could have intermittent, periodic use that would fall foul of my learned friend's construction. So that brings me on to the third of our criticisms of the judge's approach was that the judge wrongly applied a novel test for the degree of use needed if acquiescence was to follow. And that flowed from his own position of the requirement for continuous use. He then had to answer the question, what use will suffice? Now, in my submission, the answer to both is very straightforward. It's use sufficient to amount to infringement. And the judge was wrong to apply a higher threshold adapted from genuine use under the Act.
You say adapted from genuine use, but I don't see any reference in its judgment to any of the case law on genuine use.
My lord, no. It's something that appears. It may have cropped up in submissions. It's certainly something my learned friend has suggested that it derives from genuine use. But again, if it were,
well, he doesn't go through the analysis of the factors that you have to go through to decide whether there's genuine use or not.
He doesn't. But what's more, even if he were to, he's applying a far more stringent test because of the requirement for continuousness. And genuine use does not require continuous use. It's at some point within the 5-year period, one must have put the mark to use sufficient to create or maintain an act on the market for the goods and services under the market. So, my learned friend says that the judge, in fact, found that because Combe did not have continuous knowledge of the use over the period, there can't be an acquiescence because there's a need for continuous knowledge. Now, if we look at those points where he's addressed, the judge addressed, it's 250 is where he sets out the facts in terms of the nature of use over the period. So paragraph 250 on page 117. And I draw to the court's attention again, little Roman 5, which is the defendant's reliance on the use of the website, Badgersan, targeted in the UK, and that had been used in that period. But there's then a finding in the light of the evidence of Ms. Want at 254.
Can I, before you get to that, can I be just clear about little Roman 4? He says, defendants gave disclosure of their sales figures and invoices. Analysis conducted by the claimants in their written closing submissions, not challenged in closing by the defendants, calculated defendants sold a maximum of 498. Now, given that's the claimant's analysis, one could also say that it was a minimum of 498.
Well, instead of max.
No, you can't. I'll come to that.
My lord,
Well, he doesn't find that it's less than that, does he?
No, he recites sparse submissions. My lord, I will explain that in time, but I mean, there was no evidence led by the other side at all as to any sales for the period of December 2016. No evidence led by the defendants at all about any sales led before December 2016. There was disclosure, and we had to do the exercise in relation to the disclosure as to what possible sales could have taken place. And I'll make that good in a moment.
All right. Okay. I think that's enough for now. Thank you.
So, in any event, in terms of sales between these would of course be sales by the defendants to parties within the UK. It doesn't actually address the level of sales by those parties themselves going on, or the extent to which they were on shelves and visible. But again, this is all the issue in terms of continuous use comes into play because the judge held that there had to be a threshold of continuous use that were active sales of an active commercial sense, which he said was purely what the statute requires. As he puts it in 251, use on a scale which is consistent with there being a continuous intention to sell the relevant products commercially. So again, it's focusing on sales at all points there, not the website. And then if one looks at 252, 253, and 254, 252 and 253 relate to the evidence of Ms. Want as to what sales were going on in the Okay. And then at 254, in the light of this evidence, I find the claimants were simply not aware for a continuous period of 5 years of the defendant's use of their mark, but that is in the relation to the sales that were going on. It doesn't impinge, in my submission, on the website, which was there throughout. Ms. Want and her team monitored the market with a degree of care for competitor products. It's entitled to reasonably assume, as she did, that for whatever reason Wolff was simply not active in the market in the sense of actively promoting the sale of their products. So, insofar as there is a knowledge issue in relation to the sales, and that is something that could interrupt acquiescence, in my submission, it doesn't extend to the website. And further, there are to sum up, 3 points on my learned friend's contention in relation to the need for continuous knowledge. First, the point in my submission doesn't assist my learned friend unless he also wins on the need for use to be continuous. If use doesn't need to be continuous, then continuous knowledge is not necessary, even any more than continuous use is necessary.
Sorry, why not?
Because if use does not have to be continuous, then the knowledge of the use at a particular point of time, if one saying so say, let's take my cream egg example, in October of a year when there are no cream eggs on the market, there could be no knowledge of cream eggs on the market, but that's only an issue if the requirement...
But on your own argument, it wouldn't be sufficient just to know about 1 out of the 5 years. Suppose there's sales every Easter.
My lord, yes.
And the senior user knows about the first year's sales, doesn't know about years 2, 3, 4 and 5. So on your analysis, that's sufficient for continuous use.
My lord, yes.
But why would they be acquiescing if they don't know about 2, 3, 4 and 5, just because they know about 1?
My lord, I think, placed in those particular circumstances, assume there was use going on, and assume that it was reasonable for them not to have knowledge, then at that stage perhaps no acquiescence. But it's difficult facts in set points, but I take the point that I can't say on that example that the requirement for continuous knowledge stands and falls with the requirement for continuous use. Second point is, as I've expressed, the nature of the judge's finding is intimately tied into his views on level of use. So his knowledge, his level of use, and the nature of the use that was required, that is to say sales. Doesn't engage with website use, and he's really looking at knowledge of use above the threshold that he's imposed. And finally, again, taking point on continuous use, there is no logical reason in my submission why continuous knowledge would be needed for continuous acquiescence. If continuous knowledge is necessary, then my learned friend is saying that my clients would have to prove that the defendants were aware at all times of the nature of the use and that there was use going on, rather than being aware at the start of a period, being reminded of it a year later, and taking no steps in the meantime, no steps afterwards. I think in my submission, if a party has knowledge at the start of use and knowledge at some point in the course of use and knowledge at the end of the 5-year period, if they've taken no steps to restrain, then they have nonetheless acquiesced.
What if something happens in the course of the 5 years that reasonably leads them to believe that the use has stopped?
My lady,
Surely would interrupt acquiescence.
It might depend on what it is, and depend on as a matter of general propositions, possibly. As a matter of the facts of the present case, that it would not address the issue of the website use. So the use continued and has been referred to, and there's no evidence that they weren't aware of the website over that period. To say there is then a lack of if they believed that sales were no longer at the level the judge comes to, it might, on the facts, lead to a conclusion that there was something that interrupted acquiescence. But again, it would require an inquiry that the judge in my submission didn't go into. We haven't got it before you. So again, we're faced, because the judge viewed all of this through the lens of his threshold for use and sales. We're left in the dark as to what his findings actually were. And on that basis, I would say that the need to show there was something that interrupted the period of acquiescence, or some mental element that meant that standing by no longer amounted to acquiescence on the part of my friend's clients, would be something for him to establish.
Well, can you help me on that? So far as the use of the website is concerned, the evidence that was before the court, as the judge records, was from the Wayback Machine.
Yeah.
So that's evidence gathered after the event. So that doesn't establish any knowledge during the relevant period, does it?
My lord, that evidence of itself, that evidence was there, was that adduced by my friend's clients to show that there had been use through that period. And
to be sure, I understand why you say it demonstrates continuous use throughout that period. That's very clear. But we're now on to the question of awareness. Why does it demonstrate awareness?
Well, my lord, there is evidence, and I will find it, because I think there's a reference in the history. I think that the claimant were aware and saw the website, and so that's something that during the 5-year period they were aware of the use of the website. I don't think it goes so far as to say that they were, aware all day, every day, or continuously. But certainly the existence of the website, as I recall, is something that played part of it was part of the evidential background to the finding that use had begun. So and I'll okay. I mean, it's actually it's addressed in the evidence of Ms. Wund. She said it's where she says she was aware of the website.
Do we have a witness
statement in the supplemental bundle?
Yes.
Paragraph 72 on page 21. One, if I can find my supplemental bundle. So 21.
I beg your
Paragraph
pardon.
72. It's not 21. It's at page 21. Paragraph 72. I'm told.
Right.
72.
She identified what appeared to be a Vagisan UK targeted website.
That's it. In 2013.
In 2013. And then at 82.
This is the period 2013 to 2014.
Correct.
But her evidence then going forward is about monitoring of sales. To be fair, she doesn't return to the subject of the website.
And the
Paragraph 80.
judge record. Oh, sorry.
Sorry, paragraph 80. This is 2014. Charlie continued to monitor Vagisan's activities, prompted her to check whether they'd expanded, following which she noted the Vagisan website appeared to have been further developed. So, at 2014, but again, that's not within the period of suspension. That's my learned friend characterised.
All right, but what you can say is that they were certainly aware of the website prior to the period, and there's no evidence that they thought the website had been taken down.
My lord, that's that's about as far as I can go.
Yeah.
So, and then the final point, and I really do need to pick up speed on the acquiescence appeal, is really a sweeper. So our submissions are that what is required to demonstrate or to establish acquiescence for purposes of Section 48 is a period of acquiescence for 5 periods in use that is not at the level the judge required. It's use that is liable to be restrained as a matter of trademark infringement, and that there is no requirement that such use be continuous, and there is no requirement, indeed, that the knowledge necessarily be continuous. But if I'm wrong, and insofar as I'm wrong on any of those, and also that the period is not interrupted by issuing invalidity proceedings. Now, if I'm wrong, other than in relation to the question of issuing invalidity proceedings, because there it's plain that they did and that was within the period, and if that's sufficient to stop it, then that's sufficient to stop it of itself. But other than that, taking as a whole the conduct of coup, in my submission, the test is not that you have to issue proceedings within the period, but that there must be some lower level, serious and credible threat of infringement proceedings that is then followed up at some point with infringement proceedings. That is not satisfied in the round by the activity of coup. The judge considered the dispute between the parties in relation to registration globally. The judge considered negotiations and comments that have been made in negotiations between the parties. But what didn't happen at any point during the period was anything even approaching even the level of activity to oppose use that was considered in W3. So there wasn't not even a letter for action sent within the period seeking to restrain use, let alone draft proceedings. So taken in the round, we say, even if, insofar as I'm wrong on any of my submissions on the consequence of Section 48, the meaning of Section 48, the use considered by the judge was not such as, the steps taken by Kuhn considered by the judge was not such as to interrupt any acquiescence period. Obviously, I am to a degree tilting the moving target at that stage, because until you define the test. But my submission is essentially whatever the test, they didn't satisfy. So that brings me on to the Section 11 grounds of appeal. I can deal with this, I hope, relatively swiftly. There are 3 points encompassed by our appeal on Section 11, 2 in respect of Section 11 as presently in force, and 1 that relates to the earlier version of Section 11 prior to its amendment in January 2019. The point relating to the original form of Section 11 was not run below, but it's an argument of law only, and as I say, my learned friend doesn't object to it, he just says it's no good. All 3 aspects of the appeal rely on the EU, in the present one, rely on the existence of the EU comparable mark. Now, Kuhn referred to this as a clone mark, which is a neat way of saying, but in fact, it's the mark in issue, a UK mark, ending in 168, is a EU comparable mark that was granted pursuant to Section 2A of the 1994 Act. I don't propose to go into it. I think I can state the propositions that arise from it. An EU comparable mark is granted in relation to any EU mark which was in force prior to IP completion day. The application date for the EU comparable mark is taken to be the filing date of the EU mark from which it defines. So it's to be treated as if it was applied for at the date of the EU mark. And under paragraph 21A of Schedule 2A, if the EU trademark is revoked or declared invalid, then the UK comparable mark does go. So that's common ground between them. So this, our UK mark, if an elephant is successful in the EU, then the UK mark will go, if that's the consequence of the mark going in, or if that's the consequence of the appeal in the EU. Now, but unless and until that happens, there is a valid EU comparable mark on the register, and was on the register as at trial, and the pleadings were amended to rely on it. And Combe did not apply for a declaration of invalidity of that EU comparable mark in these proceedings, or indeed at any point until the 27th of January this year, which, in the light of what's going on in the EU, I think they're hedging their bets. Now, that application for a declaration of invalidity of our EU comparable mark has been stayed by the IPO, my client's request, and my client's case is that that application to have declared invalid that EU comparable mark is barred by acquiescence, which feeds into all of the issues in the present case. But also, we rely on Henderson type estoppel because we say they should have brought it as part of these proceedings, but they chose not, because they didn't do anything at trial and we'd amended to bring in reference to it. So that's the status of the EU comparable mark as it is. Turning to Section 11 in its present form, if we win on the acquiescence case here, then we succeed, in my submission, in relation to the EU comparable mark under Section 11, because Section 11 affords
That may be true,
defence.
but what does it add?
My lord, that's a fair point. In Section 11, as it brings in, there's a defence unless it were liable to be declared invalid. So yes, there's a degree of circularity, but of course, it's only relevant if the EUTM survives, because if that goes, then obviously we don't have it. But again, circularity. The judge deals with this at paragraph 269. Of his report. So these are the arguments that are advanced below. So 269.1 addresses the point that we've just discussed, and I think it's accepted, Your Lordship, that Section 11 does not add if they're precluded from if they're precluded from bringing infringement proceedings under Section 48. And then Little Roman 2, the judge said, in any event, the fact is that Combe has made an application for a declaration of invalidity, which has been successful. Now, that is the application in the EU IPO, not the application of the mark that's being relied on to give rise to the defence, albeit that the operation of the declaration is suspended automatically pending the defendant's further appeal, or as one might more fairly say, it hasn't been declared, it's not finally declared invalid yet, and so things are not yet decided. That being so, I do not see how the defendants can say that, as things currently stand, their later mark would not be declared invalid. It would be, as things currently stand, and indeed has been. There he's taking a point about the process of the appeal. Our point is that he prejudged the validity of not only the UK mark, but the EU IPO, the mark being considered by the EU IPO, when he really shouldn't have done so. So, even if I'm wrong on Section 48, in my submission, the judge should not have held that Section 11 did not apply, and this is where Section 11 might add to Section 48, because it would continue to apply until the proceedings in the IPO, or EU IPO and then following on, apply and remove the defence from my clients. So this is another consequence, perhaps, of Milan Friend's client's decision not to have these infringement proceedings stay pending the outcome of what went on in the EU IPO. Now, turning to the original provision, again, I hope to deal with this relatively swiftly. The original version of Section 11.1 was a homegrown provision within the 1994 Act. And it provided, if I can turn you to it, tab 10 of the authorities bundle, number 1. A defence which was similar to that under the 1938 Act, that a registered trademark is not infringed by the use of another registered trademark in relation to the goods or services which the latter is registered, but see Section 47.6. And Section 47.6 that is that if a mark is declared invalid, it's invalid, it's deemed never to have been made. So Section 11.1, as formulated, while there is a mark on the register, a UK mark it has to be, would afford a defence. Now, admittedly, the UK mark upon which we rely was deemed to have been filed back at the filing date of the EU mark, but did not, by operation of law, exist until we left the EU. But again, it's a mark that is, under the provision of the statute, is deemed to be on the register during the relevant period. And so, during the period prior to the amendment of the Act to remove Section 11.1, that mark, we say, provides my client with a defence against at least the financial consequences of infringement. It can't restrain any injunctive relief if we lose overall because things have moved on. But in that, and I agree, it is a slightly, it involves some careful logical parsing, but that is the position that my clients say is the result of Section 11.1 in that form. Now, against us, my learned friend says, but FCI establishes, and indeed I think my Lord Justice Arnold may have mentioned this in permission to appeal observations. FCI establishes that the ownership of a mark, the proprietorship of a registered mark, does not afford a defence to infringement. That is absolutely correct. It is a principle of trademark law that merely owning a mark does not afford a defence. But we don't rely on the mere ownership of the mark. We rely on a statutory provision. And although the principles of conforming construction require the construction, 11.1 to be construed insofar as possible within the broad ambit of conforming construction with the intention of the directive, and I have to accept that the intention of the directive was not to afford a defence in this way, there are limits to conforming construction. In particular, it's any construction that goes against the whole grain of the legislation, isn't compatible with the underlying thrust of the provision. We say it goes too far. And so I have to accept that Section 11.1 is a provision that should not have been enacted in the light of FCI. But until it was repealed, it remained in force. And it would be wrong in principle and going too far as a matter of conforming construction to construe it as if it had no meaning. And my learned friend refers to Section 10.6 of the Act to say this is another vestigial provision, but 10.6 had to be repealed. It may have been given little consideration by the judiciary and parties. It didn't seem to add anything. But here there is a defence that until its repeal, it was available to our client. So I'm going to trespass further onto my time. I'll steal time from reply to address the final aspect of my appeal, which is the counterclaim. I will do this as swiftly as possibly I can. So the basis of my appeal, so your Lordship and your Lordships and your Ladyship will recall our counterclaim is in relation to the new signed Dr. Wolff's register, rather than Dr. Krista. Our contention on the appeal is the judge wrong, although he set out the law in a way that might suggest he was going to apply it correctly, when it came to considering the counterclaim, he wrongly focused on the comparison of Vagisil and Vagisan and the likelihood of confusion that he held, and actual confusion he held, resulted from that similarity, rather than taking the step which he should have done, which is to consider it in the round as part of the mark as a whole. And why that is of particular importance is because the judge himself held at paragraph 93 on page 89, so just in the context, just give the context that is, when considering distinctiveness, the judge accepted, when considering Vagisil and Vagisan, that he accepted the proposition that Vagi or Vagis, so Vagis within Vagisil and Vagisan is the entirety of the mark bar the last two letters, are suggestive of the idea of the vagina, and Ms. Wolff accepted it was highly likely Vagisil communicated a product to do with the vagina. We say there's no particular surprise there. So in the context of that level of similarity, the judge below, considering Vagisil and Vagisan, held there was nonetheless, there was actual confusion, and comparing those two marks, Vagisil, Vagisan, he formed the view that there was infringement, and we don't challenge that. But he needed to go through the process and properly to consider the entirety of the new mark used, Dr. Wolff's Vagisan, as compared to Vagisil. And in my submission, that's not what he did. We can see that when we look at the judge's reasoning at paragraph 289 onwards. So, 289, the counterclaim consideration starts at 184. At 280, he sets out the legal approach, and he rightly refers at 286 to Lord Justice Arnold's decisions in White and Mackay and Origin Y, and says, even if part of the composite mark has an independent distinctive role, the conclusion that there is a risk of confusion is not automatic, it's still necessary to carry out a global assessment. So he's told himself to do that. We just say he didn't do it properly when it came to it. So at 289, he accepts at one that Dr. Wolff's added to front provides a degree of phonetic distinction to the composite mark and suggests whoever Dr. Wolff is, Vagisan belongs to him or her. But then at Little Roman 2, that much is true, but to my mind it still does not prevent the word Vagisan having its own independent distinctive role. Fair enough. Vagisan is the product being sold. In my submission, that's wrong. It's a fundamental error. What was being sold is Dr. Wolff's Vagisan. That is what the average consumer is interested in. So he's saying Vagisan, and that's what he's doing. So again, we can see the seeds of the difficulty in that he's focusing in on Vagisan. And then at Little Roman 3, as Ms. Wolff pointed out in her witness statement for trial, it's common for pharmaceutical and cosmetic brands to use doctor, followed by the name as a house brand. He refers to these. And then he goes, at the bottom of the page, it is therefore not, it seems to me, likely to be understood as a signifier of trade origin. With respect, I cannot see how that follows.
Well, he's just contradicting himself.
Well, I would say so, my lord. But he seems to base that on the evidence. He says, rather than an indicator of authenticity and likely effectiveness of the product, that conclusion, it seems to me, is reinforced by the evidence of Mr. Bowman, see above at 277, to the effect that he still refers to the defendant's moist cream product as Vagisan, despite the rebranding. But if you look at 277, what Mr. Bowman is referring to is the sale of Vagisan itself. 277, Mr. Bowman confirmed that in his pharmacy, the defendant's original product is still referred to as Vagisan moisturising cream, or Vagisan moist cream. So he's gone back to Vagisan rather than Dr. Wolff's Vagisan. Indeed, the point being taken was we haven't really got going on Dr. Wolff's Vagisan. So, oddity in Little Roman 3. And then Little Roman 4, the next point is one addressed at some length, namely Vagisan is likely to be confused with Vagisil. They're obviously not the same word, but sufficiently similar to give rise to confusion. It seems to be on the face of it that remains so even if the comparison is between the composite. Vagisan retains its own independent distinctive role even in the composite phrase and is very similar to Vagisil. The strong similarity suggests they spring from the same commercial source, or at any rate from sources which are linked commercially. Now what he should have done at that point is, in particular bearing in mind that he had found that Vagis is descriptive, he should have considered afresh the fact that within Dr. Wolff's Vagisan there are only a descriptive similarity in 5 letters that match with Vagisil. And he should have looked at that as a whole rather than, as he did, focusing in on Vagisil, Vagisan, and then stretching the protection going forward. So he thought he was applying the correct test, but in my submission he wasn't. And on that basis, if I'm right about that, then it is open to your lordships and your ladyship as a panel to revisit the point. And we would say that one of the key points relied on by the judge in holding that Vagisan and Vagisil were confusingly similar was, in the face of the description of Vagis, was the actual confusion. But there was no actual confusion in the context of Dr. Wolff's Vagisan and Vagisil. There's no evidence of that. And comparing those marks, Dr. Wolff's Vagisan with Vagisil, in my submission, the similarity is not such as to give there a likelihood of confusion on the part of the average consumer. So, my lord and my lady, it's 10 to 3. I'm 5 minutes beyond my self-imposed cut-off. I apologise for gabbling, I'm sure, in the last half hour or so of my submissions. But unless there are questions that you would like me to answer now rather than when I stand up in reply, I propose to let my learned friend have it.
I don't detect any more, so thank you very much, Mr. Moody-Stewart. Mr. Van Heegen.
My lady, my lords, you have gathered from my learned friends canter through the last couple of issues. There are 3 main issues before you. The statutory acquiescence. First issue, statutory acquiescence under section 48. Secondly, the alleged offence under section 11.1. And thirdly, declaration of non-infringement. Each of these has a number of sub-issues. And just so you understand the cascade in which we say this court should properly consider them, in relation to section 48, the first question this court's got to ask itself is whether or not the commencement of invalidity proceedings is sufficient as a matter of principle to interrupt the alleged period of acquiescence. Now, we say, obviously, if it is, that's the end of the acquiescence defence. Even if we're wrong about that, however, and it's not sufficient as a matter of principle, was it sufficient on the facts of the current case in the context of the preceding communications between the parties, where the judge held that Combe had said you shouldn't use the Vagisan mark in the UK? In other words, is that combination such that Combe had expressed a genuine and an unambiguous wish to assert its right to oppose the use of the later mark, which we say will be the test, or is the approximate test you need to take into account for the interruption, if as a matter of principle, invalidity commencement is not enough. Third, even if we're wrong about that, thirdly, does the person relying on acquiescence have to demonstrate continuous use of the later mark in question, or must it just simply demonstrate a use, which is what my learned friend seems to be suggesting, an infringing use? Or must it be continuous acquiescence? In other words, continuous acquiescence in a single use would be sufficient. If it has to demonstrate continuous use, does that use have to be genuine use or akin to genuine use, consistent with the party intending to sell goods under the mark on a commercial basis? If it is, then the other side haven't established that. But even if we're wrong about that, the final limit is, whatever the nature of the continuous use, was Combe actually aware of any relevant use for 5 successive years? And we say the finding of the judge, as a matter of fact, was it was not. And what my learned friend is inviting you to do is to find some facts that aren't before you and weren't before the judge. And so what I intend to do, I will do section 48 first, then I'm going to do section 11.1, and then I intend to address the declaration of non-infringement. before I start all of that, there are three general preliminary points that I just want to put down as markers. Obviously, we support the judge for the reasons he's given, and for the reasons we've set out in our skeleton. I don't intend to repeat those points orally. I intend to emphasise the points in answer to my learned friends' oral submissions and some further points that he's made by reference to his written submissions. But insofar as my learned friend seeks to criticise the judge because he's failed to address matters and or because he's supposedly wrongly addressed other matters in the judgment, this court needs to be very careful as to what the issues were before the trial judge and be careful that my learned friend is not being inadvertently unfair to the trial judge. And I want to give you at this point just three examples. I'll come back and we'll address some more substance. Firstly, before the trial judge, it wasn't suggested that the defendants did not have to establish continuous use of their later mark for the purpose of statutory acquiescence. What my learned friend's predecessor accepted was that he had to establish use throughout the 5-year period, but his submission was that it was modest and not but sufficient. Secondly, there can be no criticism of the judge that he considered the wrong mark for the purpose of section 11.1, namely the IREU. That was the mark which, again, my learned friend's predecessor suggested in their skeleton was to be relied on. They actually invited the court to rely on this mark, and they did that in writing in their opening submissions, and then they also adopted those submissions in closing, which I'll show you later as well. Thirdly, the alleged partial defence of relating to historic damages arising out of the pleading of the former section 11.1. My learned friend is quite fair that that wasn't raised before the judge below. And he's quite right to do that. And it wasn't raised for a very good reason, my lord. We can all stand back and think, why now? Because if he's right about that construction of section 11.1, no infringement proceedings could have been commenced by Combe in relation to the Valuesan mark in question until that section on his construction was amended in January 2019. And so that would have completely destroyed their acquiescence defence. And that's a point we make, I think, in paragraph 46 of our submissions, one which my learned friend hasn't addressed at all on his construction. Because, as my learned friend rightly has shown you in relation to both VAR and also to high-tech, you can't acquiesce if you're not in a position to prevent use of the underlying registered trademark. So that's the first general point. 3 examples. The second general point is that the first 2 issues raised on this appeal, namely my learned friend's purported defences under section 48 and section 11 of the mark, are interrelated, as my Lord Justice Arnold observed by saying, well, what's his ad? Because they are crucially dependent upon the appellants having a later registered valid trademark. They are statutory defences to the infringement claim which are only available to a person who is the proprietor of a registered trademark which was filed after the mark which was prima facie held to be infringed and is used by that registered proprietor in relation to the goods for which that mark is registered. Now that leads me to the third general point, and that is, on the particular facts of the case, there were these defences under section 48 and section 11.1 were, and we say continue to be, the most artificial of defences which the defendants did and could possibly have run. This is because the validity of the registered mark upon which the appellants rely was challenged by reason of the commencement of the cancellation proceedings before the EU IPO on the 2nd of December 2017, i.e. clearly within a 5-year period of first knowledge, which was held by the judge to be the end of January 2014. And by the time of the commencement of the UK proceedings for infringement, that EU IR had already been validated by the EU IPO on the 11th of September 2019. That decision is at the end of the core bundle. And that invalidity decision by the EU IPO was that the use of the Vagisan mark, as at the time it was applied for, i.e. 2012, would have given rise to a likelihood of confusion with the 2 UK registered trademarks for Vagisil, which are the subject of these UK trademark infringement proceedings. And so the Vagisan European mark should never have been registered. Now that European decision also expressly rejected the appellant's contention that Combe were not entitled to bring the invalidity proceedings because Combe had acquiesced for a continuous period of 5 years in the use of the Vagisan European registered trademark, being aware of its use. Can I just show you that very briefly, my lady, my lord?
Before you get into that,
Yes.
I want to ask you a question, the answer to which is almost certainly legally irrelevant, but I just want to ensure that we've got a complete picture. Was there any evidence before the court below as to the reasons why Combe delayed so long in bringing its infringement claim?
No, and of course we wouldn't accept that we delayed for so long. I mean, the evidence...
The elapse of time speaks for itself. You could have brought infringement proceedings years earlier. You didn't. And all I'm asking is, was there any evidence as to why not?
Well, there was a myriad of evidence. On the one hand, there were commercial negotiations going on in which we were telling them not to use it. Secondly, there was...
So one of your witnesses gave evidence saying, we didn't sue earlier because of the negotiations.
No, I'm saying that there's, the answer to my Lord's direct question is, was there direct evidence saying, I did not start the infringement proceedings for these reasons? No, there wasn't.
Right, I'm not surprised to hear that.
Fine.
I just wanted to be clear.
Fine. But I do jib at the way in which that question was put, because if we're right and the judge is right, you say huge delay, but in fact, if there'd been no use, no material use of the mark prior to December 2016, we brought proceedings in 2019, 3 years. After, and that's already...
Your infringement claim goes all the way back to the limitation period.
Of course it does, we're entitled to do that.
Yes, of course you are.
But what I'm saying, my Lord's already addressing me the question that there's been some suggestion of gross delay. Well, I would just like to put that
I didn't
back.
use the word gross.
I know you didn't, but that was the inference I drew from the question that my Lord put to me. And if it were that troubling my Lord's mind, I would say that's an illegitimate starting point for the reasons I'm beginning to explain. Because obviously, if as my Lord knows, there is a single infringement taking place at day one, and materially nothing happens thereafter, one has to take, this isn't evidence, this is just common sense, one has to take a commercial view as to whether it's reasonable or feasible commercially necessary to bring infringement proceedings. If, however, the use is huge and is causing you damage, then you do. Now, the evidence which this was huge use comes from the so-called relaunch, as held by the judge, in December 2016. And that's what triggered all the evidence of confusion. And we brought proceedings within 3 years of that.
Not exactly fast, but it doesn't matter. You're entitled to make 3
No, but I'm hoping my Lord then understands why I'm slightly reluctant to answer just simply the question no, in light of the way in which the question was put. So can I take you, as I'd like to, if I may, just briefly to the cancellation decision, which is in the core bundle behind tab 13. It was annexed to the reply and defence, the counterclaim, Annex 4, and the annex starts at page 384. And I don't need to tell you the substance of the judgment. It is, as I've said, but the one I wanted to show you was the nature of the acquiescence defence. And that acquiescence defence was run by Dr. Wolff and addressed by the court at the bottom of page 386, last two paragraphs, and over the page to the second hole punch on page 387. And what they found, in essence, was the knowledge wasn't for 5 years, and therefore bringing the invalidity proceedings could not have been acquiesced in. Sorry, they were not debarred from being acquiesced in the invalidity proceedings because they hadn't acquiesced in the use of the mark for a 5-year period. And then, you see, it says finally, that should be dismissed as unfounded.
But sorry, I'm just catching up with this because I haven't read this before.
Yep.
But the reasoning is that the applicant was aware of the use as from 29/1/2014.
That's right.
Which is consistent with the judge's finding in the present case.
Exactly. Yeah.
And then it says, the office cannot infer from news the applicant was aware of the use of the contested IR 2 years before this date.
That's
and
right.
of course, the reason why they're asking that question is because of the filing date of the invalidity.
Absolutely. Absolutely. And so it was
So
common.
the time period they were considering was different to the time period the judge was considering.
Absolutely right. Absolutely right, Milord. Absolutely right. So not in any way. So the point I'm making is, though, that the grounds for acquiescence weren't established here simply because the 5-year period had not expired.
Well, what's the relevance of that, given that we're considering with a different time period?
Because there was no suggestion here by Dr. Wolff that it was anything to do with the fact that no proceedings have been taken to restrain the use of the mark during that period, or no threats have been taken to restrain the use. The only point taken by Combe in relation to this was by Dr. Wolff, was the 5-year period hadn't expired. Now, on my learned friend's submission, I'm going to make good this amendment. On my learned friend's submission, he's saying that the criteria for acquiescence is that you must do something to restrain the use of the mark. He goes as far as saying you must bring proceedings. But even if he fails on that, he says, well, you've got to be a very serious letter and then proceedings at some stage. It's a bit flaky, we say, about whether proceedings should take place. Proceedings for infringement should take place before the 5-year period. But the point he makes continually, time and time again, is that the period for acquiescence only comes to an end. It's only stopped if you've taken that step, namely that step which is, and he says effectively, to bring infringement proceedings. Now that point clearly wasn't taken here. We say sensibly, of course not. Because we were bringing proceedings for invalidity, and the only issue when you bring proceedings for invalidity, surely has got to be, are you acquiescing in the use of the mark for a 5-year period? If you bring invalidity proceedings within 5 years, then you're certainly not. Now, the point I want to make is, Dr. Wolff never suggested they got this wrong as a matter of law. But actually, that's completely wrong, because when you come to consider acquiescence, it's not when you bring invalidity proceedings that's relevant to bringing that to an end. It's whether or not you've taken some steps to restrain the use of the sign. That's from my learned from submission. Now, I'm going to come and build on that, because I'm going to say, obviously, when you get to the section, you get to the directive, when you get to the test, it's the same criteria which acts to prevent either you bringing infringement proceedings or bringing a declaration for invalidity. Not different criteria, it's the same criteria.
As I understand it, the point you're making is a very short and simple one, namely they didn't take the point in these proceedings that they're taking before us.
They didn't take it and they never appealed it.
But so what?
Well,
I mean, either the point's a good one or it's a bad one. I mean, if they'd taken the point,
yes,
and the cancellation division had said it was a bad point,
I'm sure then we wouldn't be here at all, realistically. But the point is, it is completely inconsistent with the position they've taken here. because they should have said, actually, no, it doesn't matter, you started invalidity proceedings, because period acquiescence still continues. That's what they're submitting to you, this court. Now, the substantive point in relation to this is that what we now know is that the EU trademark is not going to be, they don't have a defence to the invalidity of the EU trademark on the basis that we have acquiesced to the use in relation to the EU trademark. And that is something, of course, which they needed to rely on, we said they needed to rely on, when they were trying to rely on section 11.1. Because as a matter of fact, what we now know is that in relation to the EU trademark, the consideration of whether we've acquiesced or not has been decided against them. And so they will not have a defence to that invalidity attack by saying that we have acquiesced in relation to that, which is the foundation of section 11.1 in the new form. And just finishing this general point, obviously, these defences, the section 11.1 defence and the section 48 defence, was only capable of being pleaded by my learned friends in this action, this infringement action, simply because the appeal process before the European Intellectual Property Office and then to the General Court and to the potentially to the Court of Justice is ongoing. By the time we started the proceedings for infringement, they'd lost at first instance in relation to the EU IPA, they lost on appeal, they had an outstanding appeal to the General Court, and we know that that's only just been heard yesterday. So it may be, but we don't know, 3 or 4 months' time.
Yeah, but this is a common problem with the EU trademark system. It takes forever to get resolved.
It is.
And given, in this particular case, the Brexit point, it may well be the case that the General Court decision is not the end of the story.
Well, it may or may not be, and there's a question about whether or not it still has relevant subject matter, and whether or not they think that's appropriate or not, or whether they're going to dismiss other facts as well. Absolutely.
Yeah, but for all we know, there's not going to be finality for another 2 or 3 years.
But just standing back from this, the concept, therefore, that we were passive in relation to the registration of their mark, and therefore the use of a registered mark, when before we brought these proceedings, we had successfully invalidated it at every single tribunal that we were able to do so. And remember, in relation to this mark, in 2017, we couldn't have brought any other invalidity proceedings other than going to Europe, because it was an EU TM. Is, we say, in terms of standing back in general context, something which this court should not forget, and should not therefore also forget when we have to look at the specific granular detail of section 48 and section 11.1. With that, my lady and my lords, I was going to go straight to whether the commencement of invalidity proceedings is sufficient as a matter of principle to interrupt the alleged period of acquiescence. And I want to do this, first of all, by just showing you the wording of section 48, which ultimately is what my lady and my lord have got to construe under this issue. And that's in the authorities bundle behind, authorities 1, behind tab 11, and section 48, which is common ground, is implementing Article 9 of the Trademark Directive, can be found at page 157 of the authorities bundle. Section 48.1, just a second hole punch behind tab 11. Now, we submit the only way of reading this section is that there is only one way of reading this section, and that is that the operation of this provision is to prevent an earlier registered trademark proprietor from applying for a declaration of invalidity or prosecuting an infringement proceedings if the single condition set out in section 48.1 is met. Now that single condition is set out at the first few words of section 48.1, which is the acquiescence for a continuous period of 5 years in the use of a registered trademark, being aware of that use. That's the condition. And I'm going to come back to, obviously, the continuous period of 5 years and awareness of use. And I just want to concentrate for the moment on acquiescence in the use of a registered trademark. That condition, namely, have they acquiesced in the use of a registered trademark, is the same whether you wish to shut out an invalidity action or wish to shut out an infringement action. The section makes for no different condition to apply uniquely for shutting out an invalidity proceedings or for shutting out an infringement proceedings. It's the same condition. What the words of the section say. Therefore, we say, if being an invalidity action ends the period of acquiescence for the purposes of entitlement to apply for declaration of invalidity, then so must it be that that's because the earlier right owner is no longer acquiescing in the use of the later registered trademark. Accordingly, we say, the earlier rights owner is not barred from bringing infringement proceedings because the test is the same. The earlier right owner is not acquiescing in the use of the later registered trademark. Now, moreover, we say, a person who is challenging the validity of the later registered trademark is opposing the very existence of that later registered trademark, because he's objecting to the very existence of the mark which provides the potential protection under section 48. Attack on a use of a registered trademark is made when you attack the registration, because section 20 only applies to later registered trademarks. It doesn't apply to use of unregistered trademarks, namely signs alone. And the judge correctly understood both those points, and that's what he addressed separately at his judgment at 192 Roman 5 and 192 Roman 6, which you've been taken to. And we say the judge was correct in relation to both those points, and that we say should be the end of the matter. Now I need to try to understand, with great respect, what my learned friend says section 48 is meant to mean. Because, again, with great respect to my learned friend, who is a very, very able advocate, I am still unclear as to what he says section 48 is meant to mean. They haven't said that clearly in their written skeleton argument, and nor in my respectful submission have they done so orally before you today, because it appears to us that they're trying to run at least two alternative interpretations. Namely, that the time period for acquiescing for invalidity is different for the time period for acquiescing for infringement actions, i.e. when it comes to an end. Or, and this is the extreme submission which he seemed to float back and forth but didn't ever pin himself down on, potentially the clock, the acquiescence clock, does not stop in relation to either commencing an invalidity proceeding or an infringement proceeding, unless steps are taken to restrain the use of the later mark. Now, if that is the case, if that is his submission, that's where it's construed, in which case seeking a declaration of invalidity would not stop the clock at all, even for an invalidity action. So you would have this absurdity because what his submission is that bringing an invalidity action is not bringing steps to restrain the use of the later mark. And if that's right, one could bring an invalidity action in the 4th year, get to trial 5th year, 1 month, and he pops up and says, you've acquiesced. That acquiescence stops me both for infringement but also for invalidity. Your invalidity action should be dismissed because it's the same criterion. And we say that is totally wrong and totally illogical. And that's what the judge understood to be illogical when he was referring to that at 192 Roman 5. Now, we also know, obviously, that submission has got to be wrong because, just at a very high level, I'm going to come back in a bit more detail in a moment. At the highest level, he seems to be suggesting the clock only stops if you bring infringement proceedings. Now, we know, and I'm going to show you in a moment, in our respectful submission, that high-tech is an example which demonstrates that acquiescence may come to an end, even if no proceedings are issued before the end of the 5-year period, as long as the earlier trademark owner has produced evidence of a genuine and unambiguous wish to assert its rights. We also know, of course, and as I've shown you, that before the EU IPO, Wolff did not assert that the invalidity proceedings were acquiesced. Sorry, he couldn't be invalidity because they were acquiesced in, because no objection to the use of registered trademark had been taken. And that's why we say, when you look at the section, you have one single criteria having two effects. And that is why, when you look at the authorities, all the key authorities state that any or an administrative action or court action initiated by the proprietor of the earlier trademark within the 5-year period has the effect of interrupting the period of acquiescence. And we've given in our skeleton, obviously, the reference to Budvar and high-tech. We've also, in our skeleton at paragraph 39b, footnote 27, given a list of the EU IPO references where they consistently refer to initiating administrative actions.
Can I be clear? Do you dispute the proposition that under some systems of law, it is possible for a trademark owner to enforce its trademark by reference to an administrative agency? So let me give a well-known example, which is the Hadopi agency in France. There's the Italian equivalent, whose name I forget. They are administrative agencies. They are empowered by domestic law to enforce intellectual property rights. I mean, most obviously copyright, because they're mainly focused on the internet. But in principle, it is possible. Without knowing the particular facts, I'm not going to say yes to those particular examples, but in theory, one could imagine that there could be administrative proceedings which are used to, or attempted to use to restrain the use of a sign. Right. So there's no magic in the expression administrative action. What tells you that it has to be invalidity?
There's no magic, but there's no case in which administrative action is used in any context which indicates that it is one of those which my Lord has indicated. Whereas administrative...
I'm sorry, I'm not sure I understand what you mean by that.
My learned friend has not sought to rely on any case, and nor have we found any case in which, when one has seen in the acquiescence cases reference to either initiating administrative action or initiating court action, there's been not one example of the sort of administrative agency being referred to.
I'm still struggling to understand what you're saying, and let me put it in my own words, and then you can tell me if I've got it right or wrong. I think what you're saying is we don't have an authority, an actual concrete example in which the issue of acquiescence has been tested by reference to an administrative action to restrain infringement.
I don't think it's not even that high. We haven't got in any of the acquiescence cases any discussion, whether by an advocate general, by the court, or any of the parties, which is recorded in any of those cases, that an administrative action is of the sort that my Lord has in mind, namely one which is akin to, I assume, bringing
you
infringement
say
proceedings.
that, but of course, Mr. Moody Smith's submission, and I appreciate you're going to take issue with this, his submission is that when you read what the Court of Justice has said, in context, the administrative action they are talking about is an administrative action to restrain use.
That's what he's saying, absolutely. And what I'm saying is it's the same nature that one has to look at for that first condition of Section 48. Namely, is this acquiescence in the use of a registered trademark? So in other words, if you bring an invalidity proceedings, is that acquiescence in the use of that registered trademark? We say, no, clearly not. And when you look at, therefore, the general references in all the authorities about whether or not the clock stops because you can bring court proceedings or administrative actions, there's not a single case where the courts have referred to administrative actions as being akin to infringement proceedings. Whereas there is a common thread in European trademark law that administrative actions is something which the Court of Justice refers to as being the first two steps in the validity opposition or the validity challenge, namely before the EU IPO and before the Board of Appeal. And the one I was just going to show you, particularly by way of example, if I could, is that which you see from the Advocate General Mengozi in Fédération Sinologique, which is in the Authorities Bundle 2, behind tab 21. Page 342. And this Advocate General 45. Moreover, as correctly stated by the Commission, to make the bringing of an action for infringement contingent on a declaration of invalidity in respect of a later trademark would, in the final analysis, entail the risk of disproportionately delaying the infringement proceedings because, in addition to waiting to OIM's decision on invalidity, which will not be reached until 2 stages of internal administrative review have been completed, the part of the earlier community trademark may have to wait the outcome of any action brought before the General Court and possibly an appeal before the Court of Justice. The earlier trademark and prejudicial trademark might therefore coexist on the market for several years with potentially serious adverse effects for the part of the earlier trademark. Now, I'm not saying that in any way binds you, my Lord, but what I'm saying is consistent entirely with our view that whenever you see a reference in the authorities and about administrative action, administrative review and so forth, it is only in relation to those first 2 stages of the OIM and Board of Appeal, and there is no case that my learned friend has cited or authority that we have seen where that is, in contrast, a reference to bringing the akin to infringement proceedings by a third-party agency. That's our submission. What, at heart, therefore, my learned friend is saying, we understand Section 48 should be interpreted, or should say, which is obviously different to what the words of the section say is, where you have not challenged the existence of the registration for 5 years, you cannot challenge the validity. And separately and discreetly, where you have not challenged the use of the later sign for 5 years, you cannot bring infringement proceedings. That's really what he wants, that's really cut down is what his submission is to you, how you should construe Section 48. And we say the problem is that it's just simply not what the section says. And there's very good reason why it's not the law, because the focus of the section is not on the use of a later sign at all, it's only on the use of a later registered mark. And it concentrates on the limitations which were imposed on the earlier registered trademark owner in respect of those later intervening registered trademark rights. And the purpose of the section, my Lord Justice Arnold asked the purpose of the section, and indeed the directive and the regulation provisions which underlie it, is to provide legal certainty to the infringer, later registered trademark proprietor, with regard to his continued use of his later registered trademark right, so that he cannot be held either to infringe the earlier right, nor can he have that registered right removed from him. And that, we say, therefore, is all of a piece. And the judge was absolutely right that the initiation of cancellation proceedings of a registered trademark is sufficient to terminate the period of acquiescence, whether for commencing invalidity or infringement proceedings. It would be nonsense otherwise. And that is from my learned friend's submission. If he's right, you could not bring invalidity proceedings and win them on the hypothesis I suggested.
I'm still struggling to understand that submission, because no limitation period works in respect of actions already commenced.
No, but that's exactly what my learned friend's submission is.
You judge the operation of any limitation period as at the date of the commencement of the relevant proceeding.
It's not. You judge that the criteria that's being asked by section 48, my lord. Careful, I read the words exactly right. The criteria you've got to ask yourself is, looking at section 48.1, has the proprietor of the earlier trademark acquiesced in the use of a registered trademark in the United Kingdom? Now, I've deliberately not dealt with the being aware of that use or the continuous period, but has they acquiesced for the continuous? Have they acquiesced in the use of the registered trademark? Now, my learned friend's submission, if I rightly understand it, is that applying for a declaration of invalidity is not not acquiescing. In other words, you are still acquiescing for the acquiescing in the use of the registered trademark in the United Kingdom, even if you apply for a declaration of invalidity.
But it could no longer, suppose you apply for a declaration of invalidity 4 years and 11 months after the acquiescence began.
Yes. Yeah.
The mere fact that you might continue to acquiesce in the use couldn't affect matters, could it? Because once you've begun the proceedings, it doesn't matter whether you're going on acquiescing or not. Well, I mean, what the section says is that when you've acquiesced, there shall cease to be an entitlement to apply.
That's right.
But if you've already applied, it doesn't matter.
But he's going to say that I disagree with you. 1 month later into the five-year period, he then says, and I'm going to strike you out, because he's going to say that you've continued to acquiesce all throughout this whole period, and you're still applying for a declaration that the later mark is invalid.
I don't think that is what he says. You may say he's wrong to say what he says, but I think he says, well, if you've applied within the 5 years, that's fine. But that doesn't mean that you can bring infringement proceedings after the 5 years. He draws that distinction. Now, you may say that's an unrealistic distinction, but I think that's what he says.
Well, let me fall back to the same thing. So he must be saying that applying for declaration for within the 5-year period means that you have not continued to acquiesce in the use of the registered trademark during that period.
4 or 5 years. He doesn't say, you might have continued to acquiesce for 4 years and 11 months, but you haven't continued to acquiesce for 5 years.
Yeah.
Therefore, you haven't lost your right to apply. If you go on acquiescing after 5 years, he says, well, that doesn't make any difference because the section says you lose your right to apply, but you've already applied.
But what he's saying is, by applying, doesn't...
You stop the clock, I think.
No, he doesn't. That's the point. Because I would take that, of course. If you apply, you stop the clock for acquiescing for a continuous period of 5 years in the use of registered trademark. I say you stop the clock.
He says you stop the clock on the application you make,
yes,
but not on any other application.
But that's right. He says it stops the clock only for the invalidity proceedings.
Yes.
And not for the infringement proceedings. We all agree with that. But I say that the consequence of that is that if it stops the clock, it means that the earlier right owner has not acquiesced for a continuous period of 5 years in the use of a registered trademark in the UK.
But you haven't at 4 years and 11 months.
Yeah, but
The question is, if you apply at 4 years and 11 months,
yes,
and then you go on acquiescing, say it's 5 years and 1 month,
yes,
on Mr. Moody Stewart's case, which I know you disagree with, your invalidity proceedings are fine because they were brought 4 years and 11 months after the beginning of the acquiescence. But you've lost the right to complain of anything else.
I understand that point, Lord. You've got my submission on it. But the point I'm trying to re-establish on the basis of what the section says is that if you have applied for a declaration of invalidity within 4 years and 11 months, that means you must have stopped acquiescing in the use of the registered trademark.
But that sort of begs the question. I mean, if applying stops the clock, then it stops the clock.
Yeah, sure. But it is a necessary question you've got to ask yourself, because if it doesn't stop the clock, if applying doesn't stop the clock, then one is continuing to acquiesce, as the judge held. You're continuing to acquiesce within the first 3 lines of section 48.1 on my learned friend's construction. You continue to acquiesce. There's been no material difference because you've applied for a declaration or not. You'll continue to acquiesce. And we say that is nonsense, because how can you continue to acquiesce when you've already made that declaration of invalidity? Because it's the same condition which you would consider when you're making that application. Now, those are asked, which I just need to pick up a couple of points that my learned friend addressed in relation to Levi Strauss, I think, and the effect of January validity of EU registration. The Levi Strauss case, my learned friend took you to paragraph 28. I probably just do it and make it good. Sorry. Can you take the Levi Strauss case out? It's at Authorities 1, tab 17, page 230. Page 230, and my learned friend took you to the first half of paragraph 28, when he was suggesting that the court was having regard to Article 9.1 acquiescence, which is right, it was, but it was also having regard to, you see, the second half of paragraph 28, having regard to Article 10, and more specifically under Articles 12.1 and 12.2 of the directive. And that's where a trademark is liable to be revoked if it's not been put to genuine use within a period of 5 years, or it's become effectively a common name as a result of the proprietor's conduct. And that can be because there are existing signs, not necessarily registered signs, used by other people, and the registered trademark owner has taken no steps to seek to restrain that common use. Article 9 of the Trademarks Directive, as we've repeatedly pointed out, refers specifically only to the use of later registered trademark owners, whereas Article 12, it's not necessarily that the later mark is a registered mark at all. So while it's true that Levi Strauss does touch on acquiescence in his reasoning in paragraph 28, it was in fact a case about Article 12.2, which you can see at paragraph 37, and it's not good authority for the proposition, which I think my learned friend seeks to rely on it, that it's specifically concerned about the use of a later sign. So that Article 9, namely acquiescence, is specifically concerned about the use of a later sign as opposed to the use of a later registered trademark. My learned friend says frequently, orally, and by reference to his written submissions, that acquiescence is all about use of a later mark. It's not use of a later registered I've laboured that point. My lady and my lords have got it, but Levi Strauss doesn't take it any further forward in relation to that. There's a short suggestion in my learned friend's written submissions that the judge misunderstood the registration as giving right to use as opposed to the right to prevent use. The judge didn't misunderstand that. He didn't fall into error in relation to that. It was common ground between the parties before the judge that registration gives no right to use per se. And the judge did not hold that registration of a later mark gave the proprietor a right to use. Rather, what he was considering was whether or not that later mark, whether it was, what he was addressing was the removal of the registration prevented the later rights owner from having a registered mark which they could use without, to fall within section 48, because of course they wouldn't have a registered mark in the first place. Finally, my learned friend mentioned orally that the judge held that the challenge to the validity of an EU registration it is not necessarily a challenge, is a challenge to the use of the registered trademark in all member states. And that's in paragraphs 42 and 43 of his written submissions. And that is correct insofar as the judge was holding that challenging the validity of an EU TM would, if successful, remove that registered trademark protection from each member state, and therefore there would be no later registered trademark of that registered mark falling within section 48 upon which a party could rely. So he then comes back and says, oh, but what could happen is if you challenge the registration of an EU trademark, it could be converted into a series of national marks. Or if you challenge the validity in relation to certain goods and services, then the EU mark may be limited to only a subset of goods and services. Now, and he criticised the judge for saying that he didn't consider these. Well, these are points that weren't raised before the judge, and they are totally unfair and inapplicable to the facts of this case anyway. But let's just take them in stage. If the earlier registered trademark is defeated and they parachute out a number of local rights, it's a different registered right which needs to be taken into account for section 48. Secondly, it's completely irrelevant and hypothetical on the facts of this case because the invalidity of the European right, which my learned friend was relying on, was firmly based on two of Combe's United Kingdom registered trademarks, which were the same United Kingdom registered trademarks which were brought in these infringement proceedings. And there was no suggestion or no attempt to carve out any existing goods or services from the EU trademark. They couldn't because all of the goods were found, as my learned friend accepted, were confusingly similar, and for the purpose of this appeal, as I understand, it accepts they were all identical. And on any view, even if a cluster of rights could have been parachuted out, it certainly could not have covered the United Kingdom, because the United Kingdom registered marks are the ones used to invalidate the European mark in the first place. That deals with issue 1. Issue 2 is even if the cancellation proceedings by themselves aren't in principle interrupting the period of acquiescence.
Well, just before you go on to issue 2, you haven't said anything in the context of issue 1 about high-tech.
No,
I mean, it's up to you as to whether you wish to say anything.
I was going to fold it into when I get to issue 2 as well, because I'm going to give you my submissions on high-tech in relation to issue 2 as well, because I say they are supportive of what we say in relation to our principle as well, because at its boldest, my learned friend submission is acquiescence only comes to an end if you bring infringement proceedings. We say high-tech is not good for that proposition. And I'm going to show you what we say the proposition is in high-tech. but in essence, it's a genuine. I'm going to garble these words, so don't take these down as words. 'Cause I'm going to show you the actual words. It's a genuine and unambiguous desire of the trademark buyer to oppose the use of the registered trademark. And we say that's consistent when you also bring invalidity proceedings. But I'm also going to show on the facts of this particular case, it's certainly consistent on the facts of this case, because what the judge found was, even if he was wrong about the invalidity, bringing the invalidity in the context of all of the prior communications, both written and oral, where Combe had said...
Yeah, sure, that's a separate point.
Evidence is that intention.
But
yeah, but there's nothing, I mean, with great respect to my there's nothing in Hightech himself which specifically touched on this point itself either.
Well,
there is,
but of course you appreciate Mr. Moody Stewart's submission is that when you look at Hightech, it's clear that when they refer to administrative action, what they're talking about is administrative action to restrain infringement.
Yes, and I say...
And that's why he relies upon it.
I'll show you that paragraph in relation to that and say that's not the case.
Yeah. I'm getting muddled. Does he not rely on it for a further point, which is while a warning letter that precedes any kind of action might be good enough, there has to be some action.
Yes, he does.
And in that sense, that directly bears on issue 1, because if it is indeed the case that Heikel means that there has to be some action,
yes,
and the English courts follow Heikel,
yes.
I
I say that, I do, because I'm fitting into it, I say that action doesn't have to be an infringement proceedings, because by definition, if it wanted to be, it could be, and it doesn't say that.
Yes, that's
and so once you move away from the fact that it doesn't necessarily be infringement proceedings, you have to ask yourself, well, what could they have in mind? What are the measures in terms of demonstrating a genuine intention to, I mustn't paraphrase it, but it's a genuine intention to, genuine and unambiguous wish to assert his or her rights to oppose the use of the later registered trademark. And we say that is sufficient. It's clearly sufficient if you bring an invalidity action. But it's certainly, on the facts of this particular case, even more so, because that's combined with the historic preceding communications where that was set in terms.
Yes, I see.
Yeah. So that's why I was going to put it all together, if that assists my lords and my lady. So, yes, so I suppose just repeat what I said, but I apologise. In relation to the second issue, our submission is, the relevant test is, as long as the earlier trademark proprietor has demonstrated a genuine and unambiguous wish to assert his or her rights to oppose the use of the later registered trademark, that is sufficient for acquiescence to stop. Now, again, I take this like jury pointers. I'm still not entirely sure what my learned friend's test is now, because his test orally to you initially was you've got to bring infringement proceedings. His test in his grounds of appeal is no, a warning letter which can be treated as akin to a threat, which is what my Lord Justice Arnold found in W3 with a gloss, which I'll come back to in a moment, would also be sufficient. And then when challenged by my lady, Lady Justice Simler, looking at, I think it's paragraphs 54, 55 of Hightech, and this is where my submission is going to be built on, is that that's quite clear. It's saying such a letter or a letter of that sort is capable as long as you do other things. What it doesn't say, those other things are either initiating infringement proceedings or doing those other things necessarily within the 5-year period. So all of those, so if you can do that to get into interruption of the period of acquiescence, then why on earth is it irrelevant, materially irrelevant, to bring to say that bringing a declaration of invalidity of the actual mark itself, the actual registration, is irrelevant? So I apologise, I've mangled those, but that's effectively what I was going to come to when I was going to show you Hightech. The first one that I was going to show you was W3, with just a little bit of a spin, because my own friend wasn't quite as full as he might have been in relation to what W3 actually found. it just that my Lord, Lord Justice Arnold may recall, but he may not. But I want to just, if I can, go back to W3, which is at tab 4. I think ultimately, my learned friend's oral submissions to you, and I am jumping around, but my learned friend's oral submissions to you are that W3 is wrong. And it's been superseded by high-tech, or should be superseded by high-tech. Just so that you are aware, in grounds 1.4 of the grounds of appeal, my 11th grounds of appeal 1.4, which is in the core bundle tab 2, page 15, you criticise the judge because what he says is, in order for the claimants to have opposed the defendant's use of the assigned badges under the purpose of section 48, the claimants had to commence administrative or court action to restrain such use within the relevant period, alternatively, by a letter before claim amounting to serious, detailed and credible threats of infringement proceedings as referred to in W3. So, in the grounds of appeal seems to be running both horses. But orally he was saying, as I understood it, he was trying to disclaim that the letter before claim amounting to serious details and credible threats of infringement proceedings would be sufficient, as it was in W3. But may I just make my very brief submissions on W3, and those can be done by turning to the authorities tab 4. And picking it up at 348, what was relied on here were two letters. It's in 348 Roman 2, specifically. It was Easy Group Inspector Clark Wilmot sent a letter for action dated the 12th of April 2011, and then subsequently, 7 months later, draft particulars of claim were then sent. Those were private, not public letters. There's no way they were sort of published. And there were no court proceedings for infringement wherever commenced. No administrative action to challenge the later mark in question was ever made. Indeed, the trademark owner did not commence any proceedings against W3 at all until they became defendants to the counterclaim from defendants to a threats case, and the claim wasn't commenced until the 21st of May 2015. Now, the issue at 349, as you will see, before the court, was on the one hand, my submission, which is that you've either got to bring in infringement proceedings or a declaration, and that writing letters wasn't enough, because, of course, if you write every 5 years, you just perpetually keep the period extended. The submissions at 351 by my learned friend was that you mustn't be passive or inactive. A letter for action, a particular claim was sufficient. Now, the obiter decision at 352 that my Lord Justice Arnold found was that the steps amounted to serious, detailed and credible threats of infringement proceedings and are relied on by W3 as such. As a matter of fact, in the same judgment, my Lord Justice Arnold found that they weren't threats, they weren't actionable threats. So they were letters which didn't amount to actionable threats for infringement.
They were threats, they weren't actionable.
They weren't actionable, exactly.
Enough to demonstrate strong objection.
Exactly right, and that's the point I'm to build up. So, and what the test was is that while that's what the court held at W3, what needed to be demonstrated was that W3 had strongly objected to W3 had strongly objected to the use. Easy Group had strongly objected to W3's use of the Easy Roommate site trademark. That was the test. And so therefore, the take-home message was that there was strong objection, even though there were no court proceedings, even though these weren't public objections, and even though no subsequent proceedings were brought until, in fact, the threatenee brought a claim for invalidity of the trademark.
Well, that's all very fine, but where does the law now stand in
Well-
light of high-tech?
Well, my lord and my lady know that you have effectively a carte blanche in relation to this, because you're not bound by this decision because this is obiter and its first instance. You're not bound by high-tech. High-tech is persuasive. You do actually have a blank sheet in relation to this. But I would urge upon
Yes,
you.
but that's why I want your
Yes.
submission
So,
as to what the right
so
answer
I'm going to give you two submissions to answer. One is I'm gratefully adopting now, having lost it before this time, the test that strongly objecting to is all you need to do. Alternatively, I'm going to adopt the test which I say comes out of high-tech, and I'm going to show you now, is that you need unequivocally to express a wish to oppose the use of the later trademark. Now, that I show is, you see that. So if we go to high-tech, which is in the second of the bundle, tab 31. And I think I can do this relatively briefly. We pick it up. The first test you'll see, or we say the first test you get in terms of assistance as to what's required is at paragraph 50. It follows from the foregoing that prior to an earlier mark or earlier right is time barred from seeking declaration of invalidity or opposing the use of a later mark applied for in good faith, where for a period of 5 consecutive years, while being aware of these, it failed to carry out an act that clearly expressed its wish to oppose the use and to remedy the alleged infringement of its rights. That's test one.
Okay, so enlighten me. How does applying for a declaration of invalidity remedy infringement of its rights?
Because once you've got rid of the registration, then they can't rely in any way on, well,
Doesn't give you any remedy at all.
it gives you a remedy because the underlying right to rely on Section 48 or Section 11 is to have a registered mark. If you're taking that away, you don't have that as a defence. Now,
But there is no injunction, no damages, no account of profits,
no, absolutely
no delivery up.
no. And
So
nor,
in what respect is there a remedy for infringement?
well, it is, in my respectful submission, it is, you've got to express the wish to oppose that use and to remedy the alleged infringement. The first step, a first step is removing the fact that they have a registered right in the first place, because you cannot use that mark as a registered right once you've taken away the registration. But I accept, my lord, I accept, my lord, on its face, but let's look at that, remedy the alleged infringement of its right. If it said remedy the alleged infringement of its registered trademark, then my lord would have an unarguable point against me. It's not. It's much more loose language about it. Say to remedy the alleged infringement of its rights. What its rights are, rights as being a prior owner of a mark, and that having the rights of a prior owner are that you can stop a later conflicting mark, and you can stop a later conflicting mark being registered, and you can stop a later conflicting mark from being an infringement of your later trademark.
Without wishing to get too deeply into the language, going back a stage, if you're
Yes.
right that bringing invalidity proceedings is enough,
Yeah.
then we don't care
We
about
don't really
this
need it exactly. Yeah.
So we assume for this purpose it's not enough.
Yeah.
Now it says you have to look for an act that clearly expressed its wish to oppose that use and to remedy the alleged infringement.
Yeah.
So presumably the act has to express the wish both to oppose and to remedy.
Yes.
Now,
So opposing means stop using, and remedy, you must get off the market. I can do it on the facts of that case, on the facts of this case, stop using and get off the market, because that's what the facts of this case relate to. So I don't need to have a general test, but on the particular facts of this case, that's what the judge found.
When you say express the wish to oppose and to remedy,
Yeah.
you say if you express the wish that the person stops doing the thing,
Yeah.
that counts as remedying.
Well, the judge has found, I'm in a very fortunate position on the facts of this case. The judge has found, as a matter of fact, in the light of the evidence of Mr. Santini, that from a commercial perspective, bringing an invalidity action is, for all intents and purposes, the same as saying you must stop using the mark. And that's finally a fact the judge found. And obviously I rely on that because, as a practical matter, that's what they were doing, and that's what Wolff understood we were doing. That's why I say the judge found, as a matter of fact. So I don't need to go as far. There may be difficult cases. I don't need to go that far because this is right in the central of a good case. So I can, on the facts of this case, say even if that meant remedy the alleged infringement is right, then there was, on the facts of this case, sufficient relation to do that. The second test, though, while we're there, we need to go through 52, which my learned friend did take you to properly. As regards to conditions under which prior to an early mark or early right may regard as having carried out an act that produces the effects referred to in paragraph 50 above, and therefore interrupts the period of limitation, the court has held that in any event, the bringing of an administrative act or court action before the expiry of the period ends acquiescence and consequently prevents limitation. So we don't need to consider that issue all over again because the court's already held that. That's not something that this high-tech court needs to consider. So it's got to be more than either bringing an infringement action or an administrative action, whatever that means, my lord.
Well, we get insight as to what it means from paragraph 53. By bringing such an action, the proprietor, and that's to say an administrative or court action, the proprietor of the earlier mark or the other earlier right unequivocally expresses his wish to oppose the use of the later mark and to remedy the alleged infringement of its rights. So Mr. Moody Smith, Mr. Moody Stewart, apologies to him, his submission.
No, I understand.
That tells you that the administrative action contemplated is one that remedies infringement.
Yes, and I say also it does, because I say this is infringement of rights is not infringement in the sense of the and brings trademark infringement proceedings per se, because infringement of rights infringes his earlier rights, which allowed him to say you shouldn't have registered the mark in the first place. So I can still run this argument, Lord. I accept it would be much harder. Frankly, it would be much harder if this had said specifically and remedy the alleged infringement of his trademark rights to secure relief by way of injunction or delivery up or costs and damages. It doesn't say that. I'm still allowed to make the submission I am in relation to this. And then, obviously, these are the powers, and my Lady Justice Simler and my Lord Justice Newey picked up with my learned friend. 54, though, where, as in the present case, the bringing of the action was preceded by sending of a warning letter, which prior to the later mark did not comply, that warning letter, not the subsequent bringing of an action, but that warning letter may interrupt the period of limitation, provided that, following the unsatisfactory response to that warning letter, the proprietor of the early mark or early mark continues to express his opposition to the use of the later mark and takes the measures available to enforce its right. But it doesn't say there by bringing infringement proceedings, which of course it could have done, and certainly doesn't say by doing that within the 5-year period.
But then it says in 55.
Yeah, 55 it says...
By bringing an administrative or court action.
No. What it says is, where appropriate, by bringing an administrative or court action, not by bringing a court action. So it's saying in terms, it's not always appropriate to bring an administrative or court action. It says in terms. Otherwise, the high-tech would simply say, this has already been decided. Boudreaux's already decided it, or whatever, the decision is quite straightforward, you've got to bring infringement proceedings. Boudreaux doesn't decide that, but that's what effectively is being the submission. And that's not what they've found. They've said in terms in relation to this that you don't need infringement proceedings.
Is that really fair? Are they not saying, well, a warning letter preceding infringement proceedings will do, but they don't say a warning letter will do on its own?
Well, they are saying that because, of course, they're not relying on the infringement proceedings taking place within the 5-year period.
Yes.
Because that's exactly what because they're doing the contrast, obviously, between 53 and 54. Because 53 is saying, bringing in action, for the purpose of this discussion, taking my Lord Justice Arnold's position, bringing in infringement proceedings, unequivocally expresses a wish to oppose the use. So that is the end of the acquiescence period. And they then contrast to that, and then say 54, but bringing the action, where the present case, the bringing of that action was preceded by sending of a warning letter, that letter may interrupt.
I mean, might it not be, they say, look, bringing proceedings of whatever kind, that does.
Yeah.
But there's an extension to that, which is, even if the proceedings are a bit after the end of the 5 years, if the warning letter has come within the 5 years and is then followed by the proceedings, that's good enough.
Yeah.
It doesn't matter that the proceedings are a little bit later. But the snag on the facts of this case is that if your invalidity proceedings are good enough, fine.
Yeah.
If they're not good enough, we don't find a warning letter preceding any relevant kind of proceedings that would do.
Yes, you do. So what you have warning letters. You then have the invalidity action.
But the invalidity action is earlier, isn't it? I mean, if the invalidity action was within time,
yes.
So if that's all right, you're home anyway.
Yes. Yeah.
If it's not all right, the mere fact that they've extended it to a warning letter in advance of proceedings doesn't help you, because the proceedings were brought within time anyway.
No, because on the facts of this case, I'm lucky. Because on the facts, if this has been a sort of neutral case, I don't need to fight the neutral case. In fact, the factual case, which is that on the facts of this case, there were preceding communications, already in writing, saying you must stop using the UK registration mark in the UK. The invalidity proceedings were then commenced, and you have the finding of fact that was understood both by Combe and by Wolff as being commercially the same as you must stop using the mark.
Yeah, I understand that submission, but before we leave high tech,
yes, and I haven't left it either. Sorry, go on.
Can I just ask you about 57? Because
yes,
this judgment's a bit unusual in the way in which the court ultimately answers the question is different in its expression to what they've said before.
Yes.
I mean, usually when you get to in the light of all the foregoing considerations, you find the court is just repeating what it's already said in summary form. But actually, that's not the case with this judgment, because what they say is must be interpreted as meaning that an act such as a warning letter, by which the proprietor of an earlier mark or rather earlier right opposes the use of a later mark, without taking the necessary steps to obtain a legally binding solution, does not stop acquiescence.
That's right. And the legally binding solution will be.
And that is what's in the dispositif.
It is
at 498.
So what they've left completely open is that legally binding solution is not bringing infringement proceedings at all necessarily. It could be you have the warning letter, you enter into negotiations, and then after the 5-year period you come to some sort of agreement, or you come to some sort, you take some other measure. But what you haven't got here, you certainly haven't got here, is and it goes back to 55, where appropriate, bring administrative or court action, because then you fail to take measures available to him to put an end to the alleged infringement of his rights. But it doesn't say that's the only means by which you can bring that to an end. Now,
well, suppose, for example, the proprietor proposed arbitration proceedings to determine the issue, and the alleged infringer agreed.
Yeah,
that might be one way.
Yeah, and say that happened on 5 years, 1 day later.
Yeah. So
now, it seems to be that high-tech was
they're allowing for alternative enforcement mechanisms. Another way might be as we were discussing earlier, an administrative agency or customs. So they are being careful not to be too prescriptive, but what they are ruling is that what's required is something that's legally binding.
What they are saying in 57, that's right, but the reason they're giving up into that is it's not excluding something which has taken place in terms of being legally binding after the 5-year period. So it could be in the circumstance be reasonable to bring an infringement action 3 years later. And that comes to a legally binding conclusion. It's not a million miles away from the facts of this case. 2 years later, in fact. Before I leave HITA, I do want to show my lady and my lords paragraph 62. Well, I should give you the context first. This is now they're dealing with the third question at 58, and you see the issue being set out in 58 is whether or not limitation consequent acquiescence may be prevented. So you can't seek a declaration of validity or and so forth, where the application initiating proceedings, although filed before, was actually then served later. And at 62, I say we also get enlightenment as to what the court had in mind as being the relevant underlying test to stop, interrupt the acquiescence. Lodging the application initiating proceedings normally reflects the genuine and unambiguous wish of the applicant to assert its rights, which is sufficient in principle to end acquiescence and consequently to interrupt the period of limitation. So that is what we say is the underlying gist test, which is run through the whole of this judgment, that insofar as you're getting persuasive support for what acquiescence is about, you know, of course, you've got to be more than just passive. You mustn't be tolerating. What you've got to do is demonstrate, we say, a genuine and unambiguous wish of the applicant to assert its rights, because that is sufficient in principle to end acquiescence. And we say that is what is done on the facts of this case, because you're asserting your rights to say that my earlier right trumps your later registration by bringing a declaration of invalidity. At the same time, you are saying don't use the Vagisan mark in the UK. And my lords would have for me, and the actual, on the specific facts of this case, the bringing of a declaration is understood also to have that effect as a matter of commercial reality. And thirdly, you then have the reinforcing or confirmatory position of what was said in the later conversation in January 2018, where they said, I'm going to take your mark off the register, I'm going to take your mark off the UK. And that the judge held to be simply repeating the position that Combe had said beforehand.
Are you about to leave, Michael?
I think I am.
Just before you do,
Yes.
I mean, you've explained how you would interpret Heikel, and you've said that the overarching test is genuine and unambiguous wish to assert your rights.
Yes.
Suppose we ended up thinking that some of the earlier parts of the judgment weren't so clearly in your favour.
Yes.
As you say, this is persuasive authority.
Yeah.
Do you say that we should follow it for whatever it means, or do you put forward a different position?
Well, I put forward the test. I said the test I'm putting forward is a fair test of what acquiescence should be, and it's open for my lords and my lady to find that test. This is the best persuasive, and my test is that it travels that middle ground, which on the one hand is to avoid passivity, and on the other hand also to avoid mere rhetoric, which is what the court is concerned about in relation to just sending warning letters. You just simply send a warning letter and use mere rhetoric. You've got no real intention ever to follow through on it, then they should be ignored. But there may be other warning letters and other circumstances which do genuinely evidence the fact that you have an intention to assert your rights. And that, I say, is the proper course for this court to follow.
And that's why you rely on W3.
Yes, because my lord got it right. This time. Not always, my lord, but that one you got right. Now, let me just check what else I need to cover off in relation to this. Yes, I mean, I should then just show the key relevant facts of the judgment for revise, if that's okay, my lady and my lords. So the judgment, I think for this purpose we can pick up tab 5, start at paragraph 209. So hopefully one finds that at 111. 209, the judge is then finding, and note again that the objection is to use, it's the use of the Vagisan on their major markets. I also think there is no doubt that looked at in the context of the earlier letter, 29th of January, UK was one of the major markets in which the principal was saying use would not be tolerated. Then again at 211, as I read it, the 4th of October letter was thus again rejecting the idea of the coexistence of major markets, was obviously maintaining the rejection to the use of the Vagisan in these markets, first made in a letter of 29th of January. And then again, you see at 213, here Kumho again objecting to the use of the mark Vagisan in the UK. They will not tolerate use even the suggested improvement of Vagisan, namely Vaginil. Implicit that obviously the idea that Vaginil is equally, if not more, objectionable. Then again, could I ask you to turn to 218? So actually, it seems to, if necessary, it seems to me entirely appropriate to look at the broader context and value of the significance of the cancellation action. What the context makes clear is that the invalidity proceedings were commenced as part of a wider, indeed global dispute about the use of the Vagisan mark in a number of different jurisdictions, including the United Kingdom. The genesis of the administrative actions taken by Combe was a disagreement evidenced very clearly in the correspondence I've referred to about the possible coexistence of the two brands and jurisdictions outside North America and Germany. Combe's very clear position was that it would not tolerate use of the Vagisan sign or mark in its major markets, the United Kingdom amongst them. Thus, when it commenced the EU IPA proceedings, after it became aware of the relaunch of Vagisan in late 2016, it was obviously doing so with a view to preventing use of the Vagisan mark in UK by Wolff, based on its principal objection to the idea of coexistence with the Wolff market. Now, in the course of his evidence, 219, Mr. Santini explained that he, as a commercial person, would make no real distinction between objecting to registration and objecting to use. He said, if there is a dispute over registration, there is a de facto dispute over use as well. It would, in my opinion, be disingenuous to suggest that a party will accept coexistence with trademark in a territory when the party is attempting to cancel your trademark in that territory. There's no such thing as having a problem with another party's registration, but being okay with their commercial use of the mark. That just does not exist. We say that's not only a reasonable thing for him to say, but that's what he did say, and what the judge then say, I agree with that evaluation at 220. Whatever one may think of it as a general statement of principle, it seems to me that on the link between the two is very plainly made out in the present case, given the context I've described. Thus, in my judgment, it's quite clear that by December 2017, at the latest, the claimants had taken steps to convert the period of use. They had made it clear that they would not tolerate such use against the background and applied to invalidate the mark. So we say...
Can you help me on this?
Yes.
The judges accepted Mr. Santini's evidence, at least in the context of the present case. But as I read it, Mr. Santini's evidence that's there being quoted
Yes.
is evidence of his own private thought processes, not of any communication with Dr. Wolff.
Well, no, because what not only is it a private process, what you then get is 226.
Oh, for sure.
Yeah.
I'm
Yeah.
saying at that point in
Yes.
time. Of course, you're absolutely right. You then come on to the January 2018 discussion.
I can't say that on that. He was saying, I can't say that the evidence that the judge was quoting there was evidence Mr. Santini was saying, I then said that to...
No.
No, I can't. But I don't say I need to go that far, because what you have to do is ask whether it's an objective demonstration of a genuine and unambiguous wish to assert rights to oppose use of the mark in the UK. And we say that it was. And then, of course, I am able to rely on the later January 2018 discussion, which the judge addresses in paragraph 226 as further reinforcing his views, which he says in 231, once he's analysed all of it. As to the impact of this analysis above, it seems to me it merely reinforced the overall assessment I have already made. So, imminent is itself enough, but even though that's wrong, then the overall context preceding assumption of that action makes it clear that in substance, Coombe's objection was to the use of the later registered trademark. The evidence of the January 2018 call, coming as it did shortly after the inception of the imminent action, merely reinforces the latter conclusion because it emphasises the context was continued and persistent disagreement about the basic idea of coexistence, which Coombe objected to in its major markets. That was well understood by Wolff, and they would have seen that as the substance of the ongoing battle they were fighting. And that's the finding of fact that I can lie on the facts of this case.
Is that going to be a convenient moment?
That I think fully is a vacant moment. I'm grateful, my Lord and my lady.
In which case, 10:30 in the morning. Sorry, Mr.
At risk of providing unwelcome gifts, German texts of Section 21 of the German Act and the directive.
Thank you.
There are 4 copies here. They're divided German Act and German directive in each one. 4 just in case the learned associate wishes to hold on to one.
No, sorry.
That's good. They are in, yes. Yes, thank you very much.
Oh, I'm not sure. Which one's the
I think that's all right. You give those to Simler.
Yeah, there's 4 sets. Yeah.
$10,000.